one of the questions you put to me the other day, I don't know if it's covered by this topic, is what would I recommend to the young people? Yes, that's what. Yes, that's important. I thought that was one of the most important questions you asked. But nowadays, since my mind goes blank at certain times, after 90 it does, it never used to before. So I thought I'd just jot it down and let you have the whole full text.
That would be very useful.
So that if you don't mind, I'll read that to you.
Yes. Please do that.
You see, in the first place, giving advice at this stage, and I am 94, sounds great. But I sometimes have a lot of diffidence in expressing myself, because how does a lawyer prepare his case, for instance?
Yes.
And that, I read many years ago, there was a famous person called Robert Jackson, a judge in the he would later become a judge of the Supreme Court, Justice Jackson. He was, incidentally, he was the man whom Roosevelt picked to conduct the Nuremberg trials.
Oh, I see.
Yes, after the Second World War. And a brilliant man. His judgments are magnificent. And what he said has always impressed me, and this is what he said. Let me read it to you. He said, as a practicing lawyer, because he was also Solicitor General before he became judge, he made 3 arguments in every case. One, that he planned, which was logical, coherent and complete.
Okay.
Second, the one he presented, which was disjointed, disappointing. And the one he did not make, the utterly devastating argument that he said, I thought of after going to bed that night. Now, after 73 years of active practice in the profession, I sometimes have this same feeling. Even now.
The same feeling.
Even now. Your best argument is perhaps when you have gone to sleep, which you ought to have made and never.
It occurs to you later.
It occurs to you later. This has often happened to me. Sometimes you dream about it also. But let me give you on how you become an advocate, because you were kind enough to tell me a few days ago what would be my take to the young advocates who listen in.
Exactly.
Yeah, this is a little long.
Yes.
And some people may.
We have all the time, sir.
Yeah, we have all the time. So once you become an advocate, this is my take on it. Once you become an advocate, you become a student of law for life. Whether you sit in a law firm, or you work in an office for an advocate, or when you begin to practice yourself before a court, and when ultimately in course of time, God willing, you sometimes become a judge.
Okay.
Because once a student of law, always a student of law. A judge is always also a student of law. Please remember, he is not any superior person. This is because no one, however senior or advanced in knowledge or in age, can ever say, I know the law. No one. Not here, not anywhere in the world today. The law is as vast and unfathomable as the starry heavens in the sky that you see on a clear night. Please remember that. And always also remember that becoming an advocate is both a responsibility as well as a badge of fame. But first things first. The first thing that all of you must remember on becoming an advocate is that English is not a foreign language. English is not a foreign language. Since 1950, it has become an Indian language because it's one of our official languages, because we didn't have a national language. You remember, we nearly never had a constitution because there was so much disparity in approach. There were 200 amendments to the famous language article of the Constitution, and it was almost not going to be passed at all. And a compromise was found, having 2 official languages, Hindi and English, and that's how it came. and that also English for 15 years. If Parliament wants, it can also abolish English and keep it as Hindi, but it hasn't done so.
It hasn't done that.
Anyway, so the first important thing is you must improve your knowledge and proficiency in English language, and this is not because we have to become anglicized. Far from it. It is to give you an opportunity to establish yourself and be successful in the profession, because always remember the law in India is and will remain English in origin. In origin. You may have translations,
Yes.
but ultimately
Yes.
you have to think of the law in English. All the great concepts in the Constitution, liberty, equality, rule of law, are all English concepts. They are not concepts which taken from any other text, even,
Yes.
not even from our ancient texts of long ago,
Yes.
scriptures. There was a famous judge called Felix Frankfurter, Justice Felix Frank of America. It's a name that it should be familiar to all of us. He was the judge whom India's constitutional advisor, Mr. B.N. Rao, had consulted when he drafted the Constitution in India.
Yes.
But he is famous also, remember, for another reason. And the reason is as follows. In May of 1954, a 12-year-old American student living in Alexandria, Virginia, wrote a letter directly to the judge and said he was interested in going into law as a career. And he requested advice from the judge. Now, Frankfurter's now famous advice to a young man interested into going into law is now in the public domain for all to read. And his advice was as follows.
Yes.
Now just listen, I'm quoting. The best way to prepare for the law is to come to the study of the law as a well-read person. Thus alone can one acquire the capacity to use the English language on paper and in speech, and with the habits of clear thinking which can only give a truly liberal education can give. So please stock your mind with the deposit of much good reading, and widen and deepen your feelings by experiencing as much as possible the wonderful mysteries of the universe, and forget about your future career.
Forget about your future career.
Unquote. Unquote. This is Frankfurter's frank advice to a young American, and it remains valid today for India. So I heartily endorse the same and pass it on to all of you. Now, this is the trouble about writing. You will find Frankfurter's advice to a law student recorded in a book called, it's a book which is out of print today, it's called The World of Law. And the book is in 2 volumes.
Okay.
The first volume is The Law as Literature. The second volume is The Law in Literature. And they are both fascinating. Fascinating. They are all extracts from standard works everywhere, all over the world.
A compilation.
Compilated, Charles Dickens, everything, they're all over. And in these 2 volumes, you will find extracts of essays, opinions, stories, records of famous trials, all compiled by an English constitutional lawyer. And these 2 volumes contain a mine of useful and excellent writing in English. If you find the book is unavailable, because it probably is, it's 60 years ago, feel free to write to me or write to the General, and we'll be glad to send some extracts which you must read and digest, and you will then be Frankfurter trained in the law.
Wonderful.
You must get Frankfurter trained in the law. So remember, the first rule on becoming an advocate is be proficient in English by stocking your mind with good reading. Second, keep yourself informed and be up to date with Indian case law. That is, decisions of the Supreme Court, of the High Courts, particularly on whole High Court. This is essential for the profession you have chosen. And I may add that whenever you have the time, don't just sit in the library and gossip. Sit in court even if you have no case and listen. You will learn and unlearn a lot of things. how to argue and how not to argue, both.
Presence in the court.
The presence in the court, because if someone is arguing and the judge says something to him, you will immediately see the reaction that he is not appreciated the argument or is not liked the argument, and you will know what is the sort of argument to make. So that sitting in court is one of the most important things for any young lawyer.
That's also an education.
That is itself your education. That is itself your education. In this way you will be, and also you will be useful to your senior in the profession and later to yourself when you appear in court. And even when you or your senior are not briefed in a case, you can be useful to at least someone unknown to you who is arguing a case in court. You can see him arguing or her arguing and assist him or her. And then you will have made it in the profession. You will have made it because you have gone a step higher. So he will remember your good deed, he or she,
Exactly.
and will surely be of help to you. Remember also that Parkinson's law applies in the profession of law more than any other. The less work there is, the less inclination there is to put your mind to it. And so the less will be your experience, and therefore the less your clients will seek you out as an advocate, and so you will have less work. All in a downward spiral, all in a downward spiral. But the more you are engaged in work, not paid work, please.
More engaged in work.
You are engaged in work, solid work, unpaid work. We did this for years together as young people. Now it's all right, we are successful, but that makes no difference. The better will be your application of mind, the sharper will get your intellect, and everything will be in an upward spiral. Only the sky will be the limit. Any work here means occupied, being occupied, not paid work, please.
Yes, occupied.
Occupied. The worst enemy of hard work, in my opinion, is a fixed monetary reward. Worst enemy. There is no incentive when your senior pays you a stipend. Of course it is necessary for you to survive. Then take the stipend, but don't depend on it forever, because you are then in the position of an employee or an office clerk. You will soon begin to work less and less, and at 5 o'clock you will wash your face in the basin and go home, which is not supposed to be what you should do. There are no office hours for a practicing advocate. Remember that. No office hours. No 11 to 5. You have to be mentally engaged day and night. And when you assist another person to argue, you must be of real use to him. This you can do only you have looked up or studied the facts, made short notes, looked up the entire law and only relevant law, etc. Because I do remember, we had a famous judge in Bombay in my time when I was young, a Parsi judge, Justice Koyaji, who always, when we used to go into his court because we had no matters, we listened to all the seniors, and suddenly he'd seen a very heavy matter, he'd look at one of us and he'd tell the senior advocate appearing, "What, Mr. So-and-so, in such a heavy matter, you are appearing all alone?" And the senior would immediately take the hint, he'd look around and say, "Yes, my lord, I appear with Mr. Nariman or with Mr. Diwan or Mr. So-and-so." And there you are made again, you are one step higher than what you would have been otherwise. So because there's something, because your attention has been focused. So this is all very, very important. And also in a court of law, remember, all relevant facts have to be stated. But there is one very important caveat to that. No, caveat. There is a section in our Evidence Act, section 165, which few people ever remember. And it says, the judge, in order to discover or obtain proper proof of relevant facts, may ask counsel or anyone else any question he pleases in any form at any time. Remember that. So all irrelevant facts are also
become relevant under 165. Yes.
So in an Indian court, as an advocate, and this is the Evidence Act of 1872 that we are speaking of. It's still good law, it's still cited. You must be prepared not only with facts of your case, but all possible permutations and combinations that can be imagined. So when you have a brief, you must always go beyond it. It is what is known as a Brandeis brief today in America. Justice Brandeis, a famous judge, he gave his name to a brief where you have to go outside your brief, look at all this other survey, others, or the areas which are around the brief, the matter, and then not just the same matter itself, because the court can ask any question it likes, and you have to be ready. You can't say, I don't know, I haven't read this. It's impossible. Next, after you have read your brief and reread it, you must take time to reflect. You must think on it. It helps greatly. And this is the advice I was given by C.K. Daftari, Chandubai Daftari. Incidentally, you must, I'll give you my book, which is just released. Release means I never release it, I release it in the market. On Chandu Daftari.
Okay.
Yeah, it's fantastic. He was a great, one of the greatest advocates of his time, like Palkewal. Anyway, it helps greatly. This is the advice I was given by Chandubai, who for many years was Advocate General of Bombay, then India's first Solicitor General, and after Motilal retired in 1963, he became India's second Attorney General from 63 to 68. In his time, Daftari was the greatest exponent of the art of advocacy in India.
Okay.
But he's long gone, so he's forgotten. And that's why a friend of mine and I together published some of his memories and things about him. I'll give you a copy.
Thank you.
Now, over time and in your progress in the profession, you will be involved in several cases.
Okay.
All of you.
Sir.
But a good lawyer keeps his important pending cases always in mind.
Sir.
They must travel with you. Your case must travel with you, whether at lunch parties or at dinner parties, when you are out for a walk, especially when you are
occupy the mind.
Occupy the mind, because suddenly you will find. I've experienced this very often. Some important problem which has worried you, and you take a walk and you just don't bother about it, and suddenly the solution comes to you. I've experienced this time out of it.
So one can't really switch off.
One can't switch off. You must never switch off, correct. Must be on, always on. Yeah. Next, as a lawyer, it is your duty to bring to the attention of the court a case already decided on the point advanced. You may then distinguish it, but cite it you must, and never cite an overruled case. My senior Sir Jamsetji Kangai used to speak of a solicitor in Bombay, he shall be nameless, who had a book consisting only of overruled cases. And whenever the going was rough in court, he would suddenly mention that case, which would flummox everybody, because everybody would go searching for it. It would only later be discovered that the wretched case has been overruled. That is what Sir Jamsetji would say. But the consequences of citing an overruled case are disastrous. You should never.
Professional misconduct, perhaps, yes, sir.
Never tell a judge also that you have a cast iron case. I've heard many counsels say this. That is absolutely clear. Because 9 times out of 10, his natural urge will be to prove that you have not a cast iron case. If you show off,
it would be a blunder to.
Yes. And do not say in court about the other side's argument, I never heard this argument before. When I use this phrase, I myself used this phrase, when I was only 10 years old at the bar, and I swore never to use it again, because the judge, who was a kindly man, smiled and immediately retorted, you are still at the beginning of your career, Mr. Nariman. In course of time, you will hear and learn many more things that you have never heard before. So it was a perfect squelch for me. And also never say your lordship will bear with me. It's a very frequent. You see,
Yes.
when
Kindly
a
bear with
judge
me,
puts another argument to you and your lordship will bear with me. No, you must answer the judge first, not your silly argument. Argument will come later. In my young days, when the judge in Bombay used to argue with me by questioning me, I used to say quite frequently, your lordships will bear with me, just to put my point across. And the judges there did not seem to mind. But then, when I came here in the Supreme Court in 1972, Chief Justice Ray was horrified by this expression. When anyone said in response to an interjection from the bench, your lordship will bear with me, Pat would come his irritable answer, then what do you think we are doing up to now? We are always bearing with you. Yeah. Never exaggerate in court. That's the fourth matter. Never exaggerate in court about the facts of your case or the applicable law, and argue in low key, not high key, low key. Avoid rhetoric. Don't be too smart. And for God's sake, don't be funny, because you will be characterized as flippant. You can't afford to be funny in court. You can go outside and be funny as you like with your colleagues, but never in court. Never in court. Unless you have at least 50 years of experience. Then you can afford to be funny. In fact, until you have established yourself in the profession, please do not indulge in what is known as pleasantries in court, because you have to be serious-minded, especially in your formative years. And never trump the judge's jokes or make it appear that you are more humorous than he is. He never will like it. If you must tell a story, tell it against yourself, never in your favor. And always remember to laugh heartily at the jokes cracked by judges from the bench, even the corny ones. But more seriously, never show irritability in court. This is very important. Leave your anger and all the vitriol that goes with it outside the courtroom. Never take it into court. If you are tempted to be angry, remember what the great Lord Eldon once said. Lord Eldon was a famous English judge. He sat for 25 years as Lord Chancellor of England. In the year 1787, as plain Mr. George Scott, a lawyer, he argued a case in the equity courts. In one case, 35 years later, the case was cited to him when, as Lord Eldon, he was presiding in the court. And Eldon said he remembered the case. And this is what he said. And very angry I was with the decision. But I have lived long enough to find out that one may be very angry and yet one may be very wrong. Beautiful.
Beautiful.
Words of pearly wisdom. Hopefully, you will live long enough to find out for yourself that you may be on occasions very angry and very wrong. The great Justice Krishna Iyer, the noble Justice Krishna Iyer, used to delight in quoting in his judgments, and you will find them in his judgment. Exhortation of Oliver Cromwell, Lord Protector of England from 1653 to 1658, to his constituents. Cromwell used to tell his people, I beseech you in the bowels of Christ, think it possible you may be mistaken. I beseech you in the bowels of Christ, think it possible you may be mistaken. As a practicing lawyer, you will find you are very often mistaken. And it is no discredit to admit that you make mistakes. Next, don't quarrel with your opponents or be nasty to them. Because if you have chosen the law as your profession, the major part of your life will be spent with colleagues at the bar. You must rub shoulders with them. You are not like doctors who have your own clinic and don't bother with other doctors. You have to be visible. You have to be with other people, with other lawyers. You have to have confrontation with other lawyers daily, day in, day out. And therefore, never quarrel with them, for God's sake, because that's the worst sort of thing that can happen. And a sense of camaraderie is essential for preservation of your own sanity.
Yes.
Otherwise, you will become slightly mad and irritable and irascible. Your compatriots will always speak well about you if you have not been mean or uncharitable to them in word or action. And remember the old English adage, dog don't eat dog. That means dog don't eat dog. Never address a court below its station. Each judge must be addressed according to the manner in which his station entitles him to. For instance, an administrative officer who presides at a hearing must be addressed as Sir. A magistrate must be addressed as Your Honor. A city court or district court judge as Your Honor. But a high court judge, always Your Lordship. Always. Sometimes omission to observe this elementary rule can be disastrous. As it was for one of my opponents in a case I recall. There used to be in my time a judge, Justice J.M. Shellett, who was first appointed a judge in the Bombay City Civil Court, then in the High Court, and finally in the Supreme Court of India from February 66 to April 73. In the City Court, a judge is always addressed as Your Honor. In the High Court, he must always be addressed as My Lord. And Justice Shellett, when he first came, was sensitive about the change in the forms of address when he became a High Court judge. As a High Court judge, he was allergic to being continued to be addressed as Your Honor. Whenever lawyers inadvertently addressed him, they would suffer by losing their case. It happened to me in my young days when I opposed another young lawyer. And the opposing advocate today is a brilliant commentator on public affairs. That's why I won't name him. He kept referring to Justice Shellett as Your Honor. And so brittle did the judge become that he ultimately delivered judgment in favor of my client. It was, of course, a wrong judgment. When the appeal came for hearing before a division bench in the Court of Appeal in Bombay, the appellant who stood up was not called upon to argue. Instead, I was asked, or the respondent, to defend the judgment. And of course, the judgment was overruled. But to his credit, you must know that Justice Shellett worked himself out of this blemish. And in the Supreme Court, to which he was finally elevated, he became a fine, seasoned judge. He had also a literary bent because he read a lot in his spare time. And he had written a good book on the life of the great Emperor Akbar. I give you the example of Justice Shellett only to indicate that some judges are more sensitive than others. Always remember that. Some more apt to take umbrage or offense more than others. So once you argue, you must be careful what you say. You have your wits about you. There is a book called by David Panic. David Panic was a great English lawyer. He has written two excellent books, one on judges, the other on advocates, and you must read both of them. In Panic's book on judges, he mentions the farcical case of one Sardar Tajendra Singh in England.
Sardar Tajendra Singh, yes.
Sardar Tajendra Singh was Indian born but brought up in England. He had no respect for the United Kingdom or its civilization or its courts. He therefore persistently refused to stand up whilst addressing the Cambridge County Court in support of his claim for some money that was owed to him. The trial judge ruled that until Tajendra Singh gave an undertaking in writing that he would stand up and address its court, his case would not be heard. Tajendra Singh was a funny fellow. He did not apologize. Instead, he went to the Court of Appeal. And at the start, 3 judges of the Court of Appeal, including a famous judge called Sir John Donaldson, then master of the role, allowed Tajendra Singh to address them sitting down. Allowed, because, as they humorously put it, to avoid prejudging the fundamental issues raised in this case. How beautifully. To avoid prejudging the fundamental issues raised in this case. A typical English understatement. But ultimately they decided that the county judge was right. He was entitled to the dignity of his office and to require Mr. Tajendra Singh to stand up. So old Tajendra Singh lost his appeal. Next, don't criticize a judge before whom you have uttered, either in the bar room or before clients. When you are in a calm or collected mood, reflect on what transpired and ask yourself whether the judge may not have been right. Otherwise, consult a senior lawyer and follow his advice. If you must say something about the conduct of a judge, say it in court or in the appeal court. never outside the court. If not, hold your peace and remain silent. Francis Bacon, who was Attorney General in England in the 17th century, your later Lord Chancellor, you describe a much-speaking judge as an ill-tuned cymbal. A cymbal is the thing which you. A much-speaking lawyer is worse. He is like a broken drum. Sounds horrible when beaten. So talk less, reflect more. And learn next to lose with dignity. Learn to lose with dignity. You have to lose. I have lost innumerable cases. You must lose with dignity. Please remember, only one side in the case can win. The other side must lose. And you must always be conscious that the judge is compelled to decide for one judge against another. And don't jump to conclusions about the judge hearing your case. Many so-called speaking judges who interrupt a lawyer's argument will disclose their mind and at the start of the case say something against your contention. Never assume the judge is against you without hearing you. He often poses questions seemingly against your client's case, but only in order to get the best out of you, not because he has been sold to the case of the other side. The entire edifice of the legal system, of which you are privileged to be a part, exists. It can only survive on the basis of mutual good faith between bench and bar.
Mutual good faith between bench and bar, yes.
And never give interviews or talk to the media about cases in which you yourself are appearing. It smacks of cheap publicity, and it is unfair to the judge because he can't retaliate. And if the judgment in the case in which you have appeared needs to be criticized, such criticism will be more appreciated when it comes from disinterested quarters, never from you. Never complain about the inadequacy of time set by the judge for your argument. You therefore expose your own incompetence of not being able to put in simple form the essence of your case. There is nothing like the constraints of time to sharpen your mind. What will then emerge will only be relevant, not useless and irrelevant. I have seen on my visit in federal courts of the United States, counsel being given 10 or at best 15 minutes to complete an argument. And judges there have told me, after reading the papers and forming one view, they have often changed after hearing the brief but persuasive arguments of counsel at the time of oral hearing.
Within those 10-15 minutes, yes.
When the time of argument is preset, and in America it is always preset. Don't complain when judges enforce it. That is the discipline of the law. I'll give you an example. Many years ago, as president of the Bar Association, I had invited Professor Archibald Cox. He was a tutor to my son when he went to Harvard. A very fine old man. I had invited him to give a series of lectures in Delhi, Bombay and Madras. He had served as Solicitor General under President John Kennedy and was one of the most cited scholars of the 20th century. He told his audience about his experience of time limits imposed by the Supreme Court of the United States when hearing cases. And he spoke about the landmark case which he had then argued. The landmark case called Regents of the University of California versus Bakke is known as Bakke's case, a case for establishing the principle of reverse discrimination. Mr. Cox was allotted 30 minutes. Then and now it is the maximum time given for oral arguments in the US Supreme Court. Please remember, 30 minutes, not more. Yes. Howsoever important the case may be. The 9 judges in turn were closely questioning Mr. Cox, and he was attempting to answer their questions because there are 9 of them all sitting together. In the US Supreme Court, an ominous bright light comes on when your time is up. Bright light. But since the point he was making was extremely interesting, Cox, even after seeing the light coming on, continued. The presiding judge, the great Chief Justice Warren Burger, pulled him up and said, "Mr. Cox, the light is on." But Cox went on for 30 seconds more, as all advocates do. This time the Chief Justice said in a louder, more peremptory tone, Mr. Cox, the light is on. And poor Cox had to sit down mid-sentence. Mid-sentence. Some years ago I read an article written by an American advising young lawyers on how to argue in the appellate court. There were 20 tips, but the last one was the most important. Last one was sit down. Sit down. It was and it remained for me the best piece of advice to a young practicing lawyer. So much for good advice.
I'm deeply obliged, sir, because this would now for years and decades be extremely helpful to the aspiring advocates who want to make a career, because you have taken trouble to jot down these from different sources, and this is the essence, if I may put in, of your more than 6-7 decades of
experience. This is all qualified by the example I gave you of Justice Jackson, of what he used to say as a lawyer. You remember, there are 3 arguments in every case. The one you plan, logical, coherent, absolutely complete, tight. The one you present, disjointed, not tight at all, disappointing. But the best is the argument you did not make. You fool, you should have made it, you did not make.
Which occur afterwards.
At night when you recollect.
This is simply brilliant, and I am deeply obliged, sir. This we come to the end of this video, and in second video we would have your articulation on few more questions.
Okay.
Thank you.